Hi, this is Council Fikowski, and in this video, we're going to be looking at the third FRQ that is required on the AP Gov exam with respect to the free response questions. And as you know, the third FRQ is requiring you to compare a required case that you have already studied to one that you've never heard of, and you're going to be comparing and contrasting those two cases. So in order to best illustrate the way to approach the third FRQ, I'm going to use the released FRQ from the 2019 exam as sort of a framework here. Now keep in mind that as we go through these are tactics that you should be utilizing to really get the maximum number of points possible. I had the privilege of grading close to about 3,000 of FRQ number 3 in 2019, so you could become quite an expert as to how to grade these based on the College Board guidelines. So what I'm going to ask you to do right now, if you are not already familiar with this FRQ, is to really just pause this and read through this non-required case of Hernandez v. Texas. If you're ready to know it, we'll continue right now. But as you have read, in a nutshell, Hernandez v. Texas is about a Mexican-American who is convicted by an all-white jury who had not had a jury of Mexican descent in at least 25 years and is convicted and sentenced to life in prison. Now, when we go through this, the big part here is not just understanding what this non-required case is about, but it's also understanding what is the question asking you to do. And for any good FRQ, you have to be able to understand the question. You might know the content, but the problem is, do you know what the question is asking? So one of the best things to go through with any FRQ is to look at the action verbs here. Identify, explain, explain. Do you know what those action verbs mean? So in identify, that's perhaps the easiest because you're simply identifying one thing. It's sort of a dry, matter-of-fact type of response. We'll get into that in a moment. And then you see explain, and that's going to require more elaboration. Most teachers typically are going to advocate for the rule of 3, where you put at least 3 sentences for each action verb in there. You can certainly do that. I always tell my students to really elaborate. So let's look at the first part here. So identify the clause in the 14th Amendment that was used as the basis for the decision in both Brown v. Board of Education and Hernandez v. Texas. So you probably already know that that is the Equal Protection Clause. That's the only acceptable answer. There's no way to put fluff into it. It's the Equal Protection Clause. It is the only one that you will receive a point. You either get a point or you don't. It's one or the other. Remember, there's no partial credit for this either. If you were inclined to put the Due Process Clause, you would not earn a point because the correct answer here is the Equal Protection Clause. And that's where you're going to really need to know your required cases. And in this respect, if you were to put the Equal Protection Clause as well as the Due Process Clause were used, nope, you still would not earn a point. You cannot contradict one answer over the other. So certainly knowing your background information, and this is probably the easiest one of the 3 parts to identify here as the Equal Protection Clause here, but you need to certainly know your content. Now when we get into Part B is asking you to explain how the facts in both, notice it uses the word both, Brown v. Board of Education and Hernandez v. Texas led to a similar decision in both cases. This isn't as straightforward as you would think. And keep in mind, this is a 2-part answer because you're being asked to explain how the facts in both Brown v. Board of Education and Hernandez v. Texas led to a similar decision in both cases. So this is a 2-point answer, but you must be able to answer the first part correctly to earn the second point. So what that means is you have to explain how the facts in Brown v. Board of Education led to a similar decision. So in this case, you had to put something about school segregation or something very close to it. You can never assume that the reader knows what you mean. You have to really spell it out. The more detail you put, the better. So you have to put something, a black student was forced to go into a white school, or whites and blacks were separated into different schools, or utilizing the phrase school segregation. If you didn't really use that type of verbiage, you're not going to be able to get a point there. And if you can't get a point about Brown v. Board of Education, then you automatically do not get a point in Hernandez v. Texas. Now here's something also very interesting. If you were to say Brown v. Board of Education case, led the court to rule that school segregation was unconstitutional, you actually would not earn a point because you're talking about the outcome and not the fact. You have to talk about the fact, not the outcome. Unfortunately, so many students are probably going to lose points if they use that type of language where they said the Supreme Court ruled. Keep in mind, they're not asking how the Supreme Court ruled. They're asking about how the facts in Brown v. Board of Education eventually led to a similar decision. So if you were able to specify school segregation, you got that point. Now the second part, you must specify jury discrimination or something about that. A Mexican person was discriminated in the court by an all-white jury. You had to basically take the facts from the first part here and somehow articulate that with respect to the discrimination. So you, again, only get that second point here if you answer the first part correctly. Keep in mind, you have to link these two together. And how do you do that? Well, you can go back to looking at the 14th Amendment. The violation of Equal Protection Clause in both cases are very much similar. But again, you cannot talk about the outcome of how the Supreme Court ruled because they're talking about the facts. So you have to use the facts from Part 1 and the facts from Part 2 to be able to get those points all together. All right, lastly, in Part C, you're going to be asked explain how an interest group could use the decision in Hernandez v. Texas to advance its agenda. So you have to think back to interest groups, and again, here we have that word explain, and you can't just assume. So the correct answer would be something to the effect of lobbying Congress to pass a bill, to expand minority rights, filing an amicus curiae brief to convince SCOTUS to consider its point of view. Those are certainly acceptable answers. But again, notice how I italicized, you must explain this process. If you were to write filing an amicus curiae brief or lobbying, that's not enough because you didn't explain. You simply just identified. You have to explain how lobbying is going to lead, or who you're going to lobby and what you want that lobbying to do. Or, just simply stating filing an amicus curiae brief, that's not enough. You have to explain who are you trying to influence? How is this going to allow it to advance its agenda? So at the end of the day, the more detail and explanation you put, the better off your FRQ is going to be. So this is going to be worth a 4-point part here. So you have 1, you have explain the facts in Brown, that's 2, explain the facts in Hernandez, that's 3, and explain how an interest group could use the decision, that makes number 4. But it's very, very important you pay close attention, never assume anything that the reader is going to understand where you're coming from, because most times the FRQ is only going to be read in a very short amount of time. So hopefully that gave you a better understanding of how you can compare these types of FRQ, or these two cases in this type of FRQ.